you. I'm very happy that Bojan spoke first, because actually he made my job much easier, because I will be able to glide over some of my slides, knowing that he actually covered some of the ground that I wanted to cover in my presentation. So yeah, but I can change slides. Okay, good. So he spoke about authoritarian legalism. And his argument was that the new authoritarians only rarely appear as wolves. Today, they are more and more clad in sheep's clothing. What it means? This is where the challenge for lawyers comes. But I will say more on this in a second. So, what are those changing paradigms that face us lawyers if we want to be a lawyer, or if you want to earn the badge of a lawyer? And Bojan mentioned that, so let me just spend only few minutes here. I think the most important thing that challenges us lawyers if we want to keep the badge of a lawyer is point number 2 and 3. That today turn to illiberalism is highly legalistic and technical. And then the law is deployed to kill off the law and liberalism and constitutionalism. And with that, the challenge is to know the techniques used by somebody claiming to be a lawyer in order to kill off the law and actually to destroy the liberal credentials of a legal order. And this is where the distinction between the lawyer and a law graduate comes into full picture. Because for those of you, people behind the destruction of a Polish constitutional court, behind the destruction of the Polish judiciary, they use the law, the legal instruments, in order to arrive at their objectives. And for me, they are law graduates. They are using the law to pursue certain objectives and goals that should be deemed as illegal from the perspective of a legal system, the spirit of the legal system and its overall objectives. And this is where the distinction between lawyers acting in defense of liberal credentials of a legal system and those who actually destroy the very credentials of this legal system come into full picture. What is becoming a lawyer? So once we graduate from a law school, we are all law graduates. And then the hard part of the process starts. Because if you want to be a lawyer, you have to earn being a lawyer. So you have to, in other words, you have to face certain challenges and show the world how you understand the law, how you understand your vocation as part of the broader social system. You explain to the world what is your narrative as a lawyer, how you are ready to defend the narrative, and then we can sit down and talk about what kind of a lawyer you are, whether you manage to move beyond the simple status of a law graduate on the way to becoming a lawyer. So we are all law graduates. And then the second order question is whether we can qualify as being a lawyer. So first of all, if we want to answer this question of whether the threshold between lawyer and a law graduate has been passed, you have to overcome the grip of fairy tales. And the fairy tale that has gripped at least many of Polish lawyers who has never become Polish lawyers and remained law graduates is this slavish belief in the textualism, in formalism, in the law as a instrument of simply social engineering, bringing about changes by simply invoking a technocratic provisions that are completely divorced from the l'esprit du droit, from the spirit of the law. So if you want to be a lawyer, you have to go beyond the text. You have to give up this deceitful allure of the letter of the law. If you want to be the lawyer, you have to know and you have to reconstruct the European narrative of law, because being a European lawyer is not something that is just haphazard. No, with being a European lawyer comes certain values, certain paradigms, and certain instruments that we deploy in order to defend the narrative. So first, you have to build the European narrative. Then you have to defend the European narrative. And then you have to understand the European consensus. Those three elements will finally make up the fabric of a lawyer. So Bojan has mentioned American scholars. And to my great surprise, something that is absolutely absent from our discussion in Europe is the term concocted by American scholars. The term goes by the name legal complex. Legal complex, it stands for a configuration, a constellation, if you like, of different legal professions in the defense of liberal constitutionalism. And with this legal complex, judges are never alone. Judges are always surrounded by legal professions, by academics, by scholars, by public prosecutors. And we lawyers who make up the legal complex in defense of the liberal constitutionalism, we have certain important tasks to fulfill. We can create a common knowledge that a violation has occurred. We can explain to the Polish people that actually the court that is trying to masquerade as a constitutional court is not a constitutional court because A, B, C, D. So we have to mobilize and coordinate the public opinion in order to overcome the collective action problem. So people do come together when they actually know what the law is, where the law stands, what is the violation of the law. And then we have to frame the issues at the defense of liberal credentials of the legal order. So we lawyers should form part of this legal complex. We should never leave the judges alone with their predicaments. So what is the European narrative that I want lawyers to defend? And there are only a few seconds that I want to focus on this because I don't have time. But the most important thing is that we lawyers have to explain to people why European integration in the first place. Why? Because we seem to be learning from the past. We seem to be learning that every political power should be a constrained political power. We should tell the people that Europe has been concocted to make sure that never again constitutionalism would become more than just a metaphor. We should believe and we should mobilize the people about fundamental rights, about the separation of powers, about the power of independent institutions. This is what we lawyers should do in the defense of this European liberal narrative. Why liberal? Because the first communities were supposed to be a club that celebrates the liberal democracy, not just majoritarian democracy, but a liberal democracy. And then you have the part that is as important as the former, the unpacking the enemy. So Bojan mentioned this authoritarian legalism. I'm going one step further and I argue that authoritarian legalism comes with a complete legal doctrine. It has certain tenets, it has certain major themes that it follows, that it implements, and it imposes on the rest of the public the impression that this is the only understanding of the legal system and what the law should represent. So I have different elements in this unpacking the enemy part. I don't have time to do it, but the most important thing is that if you want to make a distinction that is meaningful between lawyers and law graduates, you should ask the most important question. What is the rule of law for you? The rule of law is always used as a barrier, as a protection against the power of the state. So it is never employed by the state simply to punish, simply to enforce. Rule of law is protective. This inherent attribute of rule of law has been defining the post-war European settlement, because the rule of law was supposed to protect and not simply to punish in legal terms for laws infractions. And I will be happy to share my presentation later with the audience, so that you can go actually point by point what I mean by unpacking the enemy. So if we want to understand and make it meaningful, the distinction between a European lawyer and a European graduate of law, we have to focus and we have to emphasize, and this is what we are doing as part of the TRIIAL project, that we are dealing with a paradigm shift at the European level. And we lawyers should promote this paradigm shift and should explain it. We should frame the legal issues about this new paradigm. So what are the elements of this shifting paradigm? First of all, the independence of the judiciary is the essence of the fundamental right to a fair trial. The very existence of effective judicial review is of the essence for the rule of law. Article 2 of the treaty, that brings together the values that are shared by member states, is the source of a direct legal, not simply political, obligation. And member states are under a duty to have independent courts as a general matter of state organization. This paradigm has not been with us at the moment of creating the first communities. It has come to the fore as a result of certain pressures, certain tensions and attacks on what implicitly was covered behind the first treaties. And right now, we, the lawyers, are supposed to make it more explicit, to make it actually visible, to bring it to the table, that certain paradigms make the EU law what it is, make lawyers what they should be within the European public space. And then you have the question that is really occupying the minds of lawyers and law graduates alike. But here you see the difference between how we lawyers and how law graduates use Article 19 of the treaty. For law graduates at the service of the populist government of Poland and Hungary, Article 19 of the treaty is just a declaration. It's an empty manifesto that sounds nice, but it doesn't bring about legal change on the ground. For lawyers, Article 19 of the treaty that speaks of the duty of the Court of Justice and national courts to make sure that the law is observed, and of the effective judicial protection, it's a provision that really crowns the new paradigm. Article 19 is a source of enforceable, justiciable obligations that are imposed on member states acting within the domain defined by the application of EU law. And what are then the challenges? Very quickly, there are a few. First of all, there are challenges at the macro level. First of all, we have to understand that lawyers have been trained for spotting the wrong signs of dangers. And this is the tanks on the street phenomenon that Bojan referred to. There are no longer tanks on the streets as a sign of something going wrong. Now you have smart law graduates using constitutional amendments to attack the very credentials of liberal legal order. And we lawyers have to track in detail how the legal autocracy works. We have to adapt the language. We have to recognize the new signs of danger. The new signs of danger obtains when the shell of liberal constitutionalism might be preserved, but the core is being hollowed out. And on the surface, everything looks the same. but the very essence of the legal system has been changed, and we, the lawyers, have to be able to track how this process came about. We have to document the unconstitutional change and learn from it. We have to be a generalist, and we have to understand how different constitutional features interact. If you look at the Polish Constitutional Court only and how it has been emasculated, then it should be fine. The court is still there. It's still the same place in Warsaw. So what has changed? If you want to know what has changed, you have to connect the dots. And finally, and I think this is something that has been neglected. We, the lawyers, have to reach out to the wider public. We have to educate the others because, and this is my final point, and I called it epilogue, or a new prologue with the question mark. So we, the lawyers, have to teach the people how thinking about a democracy, liberal democracy, goes well beyond the constitutional and institutional design. This behavioral register has been lagging for over 30 years now. The habits of heart that we lawyers are supposed to nurture, that we lawyers are supposed to develop, are always a necessary complement to a well-designed constitution. Civil society, empowerment, engagement, education. This is where the challenge of us lawyers resides. We have to move beyond the text, and we have to help people understand the practice to make the rule of law a living experience. And finally, we have to understand and we have to educate the people that institutions, no matter how perfectly designed, can only do so much. The constitutional courts will always die in loneliness in the future if they are not backed up by the public support, if they are not understood by the citizens. So this is my argument. We'll be happy to answer all the questions, and then of course share the PowerPoint presentation. I thank you for your patience, and I'm really sorry for being super fast and maybe skipping some of the important parts of my argument. Thank you.